the Framework Convention on Climate Change, Convention on the Law of Sea, the Moon Treaty, and the Convention on Biological Diversity. To mention some principles, it's Principle 21 of Stockholm, Principle 2 of the Rio Declaration, and also the results of Montevideo, Johannesburg, the Millennium Declaration, and the World Summit outcome, which all always have stressed the importance of the common interest idea. This state practice manifests that in the environmental sector today, the erga omnes concept has become an essential part of international environmental customary law. And as highlighted by Honorable Justice Benuna, customary law is binding in the same way as treaty law. What is missing? You have to make it more concrete and to specify it. And to that we will come later. The ILC now by Article 48, I have shown, has codified the erga omnes concept. Well, what is the use of this construction? Erga omnes obligations in a case of a gap of rules, for instance, if treaty rules are lacking, could protect and preserve the global commons, such as the high seas, the seabed beyond national jurisdiction, the atmosphere, outer space, in fighting the problem of space debris, which is a tremendous problem for the time being, and give also protection for living resources found or in passing through those areas I've mentioned. And even if special treaty regulations exist, the erga omnes concept could give helpful guidance in situations of necessary interpretation of the norms concerned, or to be useful in dispute settlement situations. It is also very valuable in giving incentives and creating more consciousness for the governance and protection of the global commons. We debated this morning. Should it be an instrument to give pressure on our politicians, on Ms. Merkel, to promote the negotiations in the climate change context? I will inform you now briefly on the recent state of the state liability project. That has to be differentiated from the state responsibility concept. In 1997, the ILC decided to set aside for separate treatment questions relating to responsibility arising out of the performance of certain lawful activities being based on the so-called responsibility for risk. In 2001, the Commission adopted draft articles on prevention of transboundary harm from hazardous activities, including a comprehensive commentary. The provisions are formulated in form of legally binding articles, giving instructions for action or containing mere statements. They deal with the concept of prevention in the context of authorization and regulation of hazardous activities, which pose a significant risk of transboundary harm. Prevention in this sense, as procedure or as duty, deals with the phase prior to the situation where significant harm might occur. By applying activities which are not prohibited by international law and which involve a risk by the physical consequences, the wording shows that this project is separated from the state responsibility concept. The global commons are not addressed in this program. But interesting is the definition of the concept of risk, which was addressed as well by Judge Benuna. It says harm or risk is encompassing a low probability of causing disastrous transboundary harm or high probability of causing significant transboundary harm. And also the environment per se is protected. That is also progress achieved. I see that I have only 2 minutes. Therefore, I come to the articles on state liability, they attempt to protect the environment per se and to guarantee a compensation of the individual victim. They are formulated in a non-binding set of draft principles, and they are very progressive. That is exemplified by the definition of damage, which contains in a nearly exhaustive list all the elements: loss of life, personal injury, loss of damage or property, but these are the standard formulations. They contain also the loss and impairment of the environment, including the consequences. That means cost of reasonable measures of reinstatement. The environment per se is protected, including loss of ecological and aesthetical values. So what is seen in the contents of prompt and adequate compensation, which is to be paid to all victims. Here, the measures specifically include the imposition of liability without proof of fault on the operator. And by this shift of the classical state liability concept on the individual polluter, that is for me a shift from state liability on civil liability being based on law on torts. What is excluded is law of neighborhood. It's not addressed. And important is that these prescriptions provide also recourse to international claim settlement procedures. Thereby, the way is open to international arbitral proceedings, lump sum payments, or international claims bodies such as UN Compensation Commission. Please allow me a last word. I will be very brief. On the UNEP guidelines for the development of domestic legislation on liability, which have been adopted on February of this year. Yes, I come to the end. Only the purpose is, these are voluntary guidelines, and they want to assist in particular developing countries and countries with economics in transition to establish national legislation, and they are divided in the field of domestic legislation on liability, response action, and compensation. That is the one part, and the other concerns national legislation on access to information, public participation, and access to justice in environmental matters. To comprise it, the liability approach is also centered on the operator's liability. You see what our chairman mentioned this morning. We have a shift on the civil liability field. That is a general trend now. And it also concerns the application of the more favorable law rule. So, all told, we have enough new progress in the field of protecting the global commons, of the environment per se, and of access to international judicial instruments. It now depends on the preparedness and willingness of the states to fill these numerous progressive legal tools with life and enforce them. That would be helpful to enhance the protection of the environment. Thank you very much.
Thank you very much.